So good morning, everyone. Welcome to the third and final day of our first Ustoria conference. Our keynote lecturer for today is Professor Marian Rewekamp, who is the Humboldt Chair at the College of Mexico, and she will be talking about law codes and communities of female protest in European history, which you can see already on the slide in front of you. Thank you very much for giving this lecture at our conference, despite attending another conference at the same time yourself. So this must be an extra workload, but we are very grateful to have you here with us. The floor is yours.
Actually, thank you very much for having me, because the conference I'm attending is not exactly my topic anymore, and the conference you're working is much more in the area I really work on currently. But even more pleased I am to join you today and send my best greetings from Germany currently. Thank you also for organizing the conference. I have been so pleased to see that someone is starting to work in the area that I find is still a little under-researched. Not a little, it's basically under-researched. So I hope that many of you who are attending, students, are going to work in the area you have been talking about the last days, and I'm going to talk about now. And now, without any further talks, I start the topic. If you don't understand me, please speak up. If I'm talking too long, please speak up. If you have questions in between, even so, speak up. All right. So the heart of this lecture will be the relationship of women with the law and how it is manifested in legal codes, with civil law in my case, and even more specific with family law, because the civil law restrained all over Europe women's autonomy to function as independent persons in the law and in consequence also in society. To single out and focus one legal field, as I'm doing now, is already a bit tricky issue, as all different legal areas work together to form a bulwark poised against women's equality law in law. Equal rights in the family meant the demand for equality under private law, and it would only be one step on the road to political equality, as only citizens with full legal personality can contract and act legally. And only these citizens have the ability to possess public rights as well. On the other hand, citizens with public rights are the only ones who can influence with their votes the forming of law and their fates by exercising their vote. So women, being excluded from private and public rights, were effectively excluded not only from having any rights, but from breaking free from the legal discrimination. They were held down by two locks, if you want to phrase it like this. If they could break one, they thought they could start fighting breaking the other one. Legally logical, it would be to first break the first one, the legal personality in civil law, in order to gain afterwards the public rights. But many women's movements in this time decided to first start focusing on the suffrage rights, in the understanding that with them they could work as basic rights to change all the other inequalities of law in the law in the parliaments. So we have to keep that in mind, that the story of women's rights in civil law, I forgot to change, is strongly intertwined with the story of suffrage and public law. They conditioned each other in form of a deadlock, or as a double bind, as historian Gisela Bock has called it. It was hard to escape the discrimination within the family without gaining suffrage, and it was logically impossible to gain suffrage without gaining full legal capacity in private law before, even though that is exactly how it has happened in most cases later. Considering that women's first experiences with the law had been usually experiences of injustice, it is hardly surprising that women in the women's movement maintain an ambivalent relationship with the law. On the other hand, women and women's movements have used the law also as a motor of change. This ambivalence of the law, understood on one hand as an instrument of domination, but also as an engine away from dependence and oppression, makes the legal relationship as interesting as crucial. The struggles in different European countries were remarkably similar in historical patterns and in their interconnectedness to efforts for women's advancements. These interconnections developed partly due to the international women's movement that in a certain way coordinated this common struggle, but it is also partly due to spreading ideas of enlightenment, of equal rights, of human rights, of liberalism, socialism that claimed equal rights for all humans, including and depending on the isms also of women. It must be noted, however, that the legal issues are usually neglected in the history of women, or they appear to be a marginal issue reserved for specialists like us. With my talk, I would like to contribute to the nascent field of European women's legal history and to highlight the importance of law and the legal system for women in general and the history of the feminist movement in particular. My work is based on the common work of historian Sarah Kimball and me, and of course we are drawing on the work of many before us, such as Gisela Bock, whom I have mentioned, Karen Offen, Ute Gerhardt, and only to mention some of them. Here's the organization of the talk. First, I try to provide an overview over the legal situation of women in the context of some national legal codifications of the 18th and 19th century, and then I will talk about women's legal struggles against these norms. I'm starting with the codifications because before they were introduced, the difficulties of drawing European legal comparisons lays especially in the diversity and the abundance of different legal rules and sources prior to the standardization by national codes, exactly in the attempt to unify and simplify the legal sources. Napoleon himself wrote in 1808, I'm citing, "The code did more to extend and consolidate my regime in Europe than my greatest military victory." It should be remembered that the legal map of Europe, equally as the geographical map, resembled small piece puzzles in which legal customs were handed down in form of jus commune, a kind of customary law, local statutes, law of states, or fiefdoms mixed and also changed with every single war and changes of territories to different occupying forces. On the former territory of the Holy Roman Empire, only 39 free cities with their own rules existed, and all sovereign in their power. In Austria, the Austrian civil law of 1811 was only implanted in the central states of the empire, meaning altogether there were various laws overlapping, often in one territory. And the Code Napoleon did not only influence or was partly adopted in large parts of Europe, but in the world. But this particularism of the law, as well as the new nation building, I'm thinking of Germany or Italy here, but also many failed attempts in the east of Europe, posed a problem not only for the contemporaries, but also for researchers like us today. I'm going to start and focus a bit on Germany. This is due to my research focus, but as my focus is now also extending to Europe, I try to combine them and draw a bigger picture. The talk will first focus on the legal codes and then the implemented discrimination of married women. Then I will talk about women's reaction towards these laws over the time, especially the reform movement in the interwar years. And all the way in the end, I will touch the work and influence of the international women's movements in this process, but this will be very briefly. Let's start with point 1, legal codes and women's discrimination. The first codes emerged from different sources. One was the impetus to place the ideals of the Enlightenment into legal form. The idea that men were created free and equal by nature on one hand, but were different by nature on the other, found their ways also into the law. Jurists such like Robert Josier Potier in France, William Blackstone in England, Christian Wolff in Germany formed the idea of the nature law for the legal codes emerging within the last part of the 18th century. During this codification process, jurists and state officials took the overlapping legal tradition of Roman law and local laws and created unified codes that typically strengthened the facility of the state and at the same time also the patriarch within the family. At the same time, they constituted also an effort to create national unity and thus ended a common legal European tradition that we're trying to consolidate again a little bit in the attempt to create a common European law. The first German codifications the Codex Maximianus Bavaricus from 1756, and then later the Prussian civil law, the so-called Landrecht, which both actually formulated for the first time the legal equality of the sexes. The Austrian Civil Code of 1811 did not even mention the equality of the sexes because its author, Franz von Zeiler, thought it was a matter of course that a man and women should be equal in private law. Considering this, these codifications are highly rightly regarded as a marking progress for women's legal status, as the former gender guardianship of men and women was finally ended. This was also the case in all countries influenced by the German law, such as Central Europe and Scandinavia. The gender guardianship, in German law they called it Mund, or in Latin cura sexis, meant that all women, married or not, had to be legally always represented by a male. So women were basically legally incompetent to enter contracts or appear in court. Here we find all over Europe gradually different variations of this legal tutelage. In trade or in business, women were often exempted from it. And in Spain, where for a long time men were usually absent because of wars, the law also found constructions to make women for this time legally competent. But the basic idea was to keep women legally incompetent. The reasons for that were usually that women, according to their natures, lacked necessary intellectual abilities and were also supposed to take care of home and the family. Later, it was also argued that women had to be protected given their inexperience and lack of judgment within the law. This all changed with the ideas of the French Revolution and the Enlightenment and the ideas that principally all humans were equal, also women. Thus, it was only consequent that with this idea, the gendered guardianship was lifted. Women should be legally competent, as the general settings of law codes often stressed. But since the role of women in the family should not be touched, the codes reintroduced now a guardianship for married women. In the Prussian law, for example, masculine power was reinforced as men were made legal heads of households, and the codes prescribed the husband's authority over his wife in intimate detail. The spouses, The spouses were obligated to perform the conjugal duty for the purposes of procreation. The enforceability of many of these legal requirements was doubtful, and yet the law spoke to the social expectations that the family serve reproductive purposes within a patriarchal society. Women also lost the administration of their property to their husbands, but the option to negotiate in a marriage contract the right to their reserved property. On the other hand, the code had some regulations that were an improvement of the previous legal situation for women. Divorce was made possible under certain circumstances, among them, uncommon for the times, the possibility of divorce based on aversion. Relatively liberal was also the legal situation of the unwed mother and their children. These relative liberal regulations made conservatives and clerics very upset. They called the law lax and frivolous because they saw the illegitimate children and their mothers as a challenge to the basic order of bourgeois society, which according to them put the real family at risk. It was actually the prominent and celebrated lawyer Savigny who succeeded around the middle of the 19th century in coalition with conservative church circles to enforce a divorce reform, the divorce process considerably more difficult than before. After the failure of the 1848 revolution, the rights of unwed mothers were cut severely, particularly allowing men to claim that the woman had intercourse with other men at the same time and the grandparents were not financially liable to the unwed mothers anymore. At the same time, women's property rights were limited as well. All these limitations were adopted and tightened in the German Civil Code of 1900 to women's disadvantage. The law tried to balance the growing feeling of insecurity in the society caused by the change of industrialization, urbanization, pauperization, etc., by providing a safe haven, at least in home. The specific bourgeois patriotism went beyond the traditional legal privileges of men, as it tried to stabilize the family, the society, and finally also the state order with the instrument of family law. The state had created a new order of the family, as Jacques Lancelot has called it. This observation is not only true for the German case, but a common feature for the legal development all over Europe. French jurists had been impressed with the Prussian Landrecht and it had it translated to inform their work to consolidate the French civil code, but alas, without adopting the legal terms of the Landrecht favoring the women. The French revolutionaries had secularized marriage and liberalized divorce in 1792, and thus provided women with some rights in the family. Women, as Olympe de Gouges, with her demands for equal rights for mothers, frightened the society as strongly that the backlash of the civil code was so strong that it traumatized the French women's movement's case for over a century. In fact, the resulting French code comprehensively harmed women's rights not only within France, but within Europe and abroad during the 19th and 20th century. In France, women's rights varied under customary regional laws from a multiplicity of sources prior to the promulgation of the French Civil Code from 1804. The code unified canon law, Roman law, customary law, and under Enlightenment precepts and under Napoleon's own patriarchal attitudes. While it was drafted to abolish privileges of order in the church, it offered, with its guarantees for liberty and property, a legal framework for a market society based on property ownership. Over 200 paragraphs regulated the right of the husband to administer his wife's property. The paragraphs limiting women's rights in the marriage were short, with around 15 of them, but impacted women all over the world. These paragraphs stressed the ownership of the husband over his wife. It legitimized the subordination of women and the reinforcement of male authority by empowering a husband's control over the person and the property of his wife. In marriage, a wife now owned her husband obedience, and he was charged with providing her with protection. This latter article reigned in force until 1938. Harsh sanctions were imposed against women's adultery, including the possibility of prison sentences and/or divorce, to ensure the paternity of men for the transmission of property within the family. By contrast, a husband was not restricted from engaging in extramarital affairs unless he brought his lover home. The Napoleonic Code retained civil marriage as an affirmation of state authority over that of the Catholic Church. Divorce by mutual consent was restricted to 3 causes: criminal conviction of a spouse, spousal abuse, and adultery, and reinstated only in 1884. And for non-married women and their children, the code introduced new regulations that tightened the situation into the impossible. Women were forbidden to appeal for child support or alimony from the father. This has never happened before in the history of French law, that unwedded mothers and their children had no rights towards the biological father. This regulation was only appealed in 1912 due to a long pressure of the French women's movement. The possibility of seeking to have paternity recognized was only fully lifted in 1972, and illegitimate children were only recognized fully in 2003 and 2005, in fact a little bit earlier than in Germany. To sum this up, in the words of Marianne Weber, the wife of Max Weber, who in 1907 wrote a kind of first legal history of women, the Napoleonic Code, in contrast to other codification of the time, preserved the traits of medieval patriarchy the longest and in its purest form. The same as we can see in the Prussian law in the Code Napoleon, we can observe in Austrian law. Also here, in the paragraph 16 of the Civil Code, expressed that all men have innate rights, but also her married women were put under tutelage here. The Austrian Civil Code was drafted to unify the diversity of legal sources in the Habsburg lands, a territory that stretched from Galicia to Hungary and to northern Italy and parts of the later Yugoslavia. It allowed women a certain degree of autonomy. They could, for example, enter in contracts or go to court. But within the family, the husband was also the head of the family and possessed marital authority over his wife. The Austrian Civil Code also constituted the separation of property, but with the time the legal opinion changed and towards man's rights to administer the property of the wife. Curiously, it ruled divorce, not uniform, but depending on the different religions. For Catholics, it remained forbidden, but it was possible for Jews and Protestants. And it remained more open for illegitimate children and their mothers than the French law. In the Kingdom of Serbia and later in the respective part of the Kingdom of Yugoslavia, The Serbian civil code had been adopted in 1844. Montenegro had its own customary law. The Austrian civil code was in force in Croatia and Slavonia and in other parts, while the Hungarian civil code covered the Vojvodina and the Sharia law was in fact in Bosnia and Herzegovina. There was a wide range of different regulations concerning marriage, divorce, and alimony in the territory of the later Yugoslavia. But as a common basic denominator, it was evident that all the areas the law sanctioned was the equality of the sexes. In the Scandinavian legal context, we find patterns that differ a little bit from the ones so far presented. In the late 19th century, the Nordic countries also started a process of legal reforms, less to unify their national laws, but to cooperate among themselves in order to allow easier business negotiations between these countries. But this process proved to be more difficult where family law was concerned. The gender tutelage had also been replaced in all these countries around the mid of the 19th century, and married women were granted inheritance and property rights by the end of the century. In the beginning of the 20th century, women gained early suffrage rights, and in the 1920s, women were also granted new rights within the family. 1920 in Sweden, 1924 in Denmark, 27 in Norway, and 29 in Finland. They were the pioneering countries in terms of equal rights in the family within Europe and served as examples for all the other reform movements of the interwar years. The reasons for this early development in comparison with the rest of Europe might lay within the fact that the women's movements formed early alliances with the workers' movements and the socialists, and that women in general were more important for the societies in their transition from agrarian to industrial societies, as well as in the general nation building process. In English common law, women were under the coverture of men. Jurist William Blackstone remarked that, by marriage, the husband and the wife are one person in law. That is, the very being or legal existence of woman is suspended during marriage. In English law from the early 17th century, the married woman was denied the right to contract because she had no separate legal identity or right to her own property, unlike the unmarried woman was a femme sole. As Ute Gerhard wrote, the legal situations of wives not only contradicted the legal position of unmarried women, but also was a blatant defiance of early constitutional institutions in England, its parliamentary traditions, its separation of powers and constitutional guarantee of property, and came under increasing pressure with growing industrialization and commercialization. The Married Women's Property Act of 1882 largely disrupted the legal process by which wives became subsumed under the authority of their husbands through coverture. Married women were no longer required to surrender their personal property in marriage and could own, buy, and separate their property. Their legal identity as individuals was restored. Yet the act did not affect the personal relationship of spouses, in that a wife was bound to follow her husband's domicile at home and abroad and to cohabit with him if he so requires. And fathers also continued to benefit from the guardianship rights over their children. In cases of divorce, the court gave guardianship to the innocent party. To sum up, we find similar contradictions within the same legal codes because all humans were declared equal, while married women lost their rights upon marriage, subjecting them to a spouse's power and authority. All the enlightened codes were intended to restructure the modern industrial society, make trade and business easier and more equal, guaranteeing property and liberty for all men. They also created new bonds for married women. These ideas spread with the legal transfer of all these codes all over Europe. As a result of the Napoleonic Wars, the French code spread its influence broadly to include Italy, Netherlands, Luxembourg, Belgium, Spain, Portugal, Romania, parts of Germany, parts of the later Yugoslavia, and Poland, as well as French colonies and beyond to Quebec, Louisiana, and much of Latin America as well as Northern Africa and parts of the Middle East. The Austrian civil code was valid in many areas in East Central Europe. In many countries, different legal codes were in effect, and it was the case in Germany, Czechoslovakia, or the later Czechoslovakia, or Italy, for example. Prior to the political and legal unification of Italy, the Austrian civil code influenced the northern jurisdictions, and the French civil code was imposed in much of the Italian peninsula. Unification occurred through the Italian Civil Code of 1865, modeled on the French. The modernization of law in 1865, however, did not completely exclude the previous laws and procedures. The testimony of women, for example, was valued of 1/2 to 1/3 of that of a man, and it was permitted, if it was permitted at all, prior to 1877. The Italian code differed from the French by failing to provide provisions for divorce, a decision designed to protect state relations with the Vatican and the Catholic Church. The influence of the Church would stall divorce reform until the 1970s. Now let's come to the next point of the second chapter, to feminist challenges to women's unequal legal status and family law. The ideas of the Enlightenment, the French Revolution, and the consequent revolutions of 1848 in many European countries led the ideological and political groundwork that was useful to first waves of women's rights movement in 19th century Germany. Luise Otto Peters claimed that the revolutionary men have forgotten women, and thus women had to demand their rights themselves in an organized movement. Let's claim our rights ourselves, she said. Let's ask for them in the name of humanity and to appellate no other judge but to humanity, or if you want to say it like that, to natural justice. The emergent women's movement used the same arguments and theories as the male revolutionists had used: equality as human right independent from the gender and based on natural justice. The young women's movement focused first on equality, on equal education and the right to work as well. Family law was not yet within the focus of German women. This changed when the German Civil Code came up for the codification in the 1870s. Now confronted with new, harsher family law rules, the women's movement's criticism concentrated on the inequalities women suffered in marriage, especially the denial of their control over themselves and their children, their earned income, and their inherited property. The struggle by the German women's movement against the civil code before 1900, the so-called Frauenlandsturm, developed in the most significant reform effort the women's movement had undertaken in its entire history. Women challenged the civil law in a number of petitions. One of the civil law petitions against the codification in 1899 pointed out: in other legal areas, women are responsible legal personalities. Only in case of marriage, women still are under the guardianship of men. The petition stressed that since serfdom and feudalism had ended within Europe, the only legal situation that enslaved humans were the contract of marriage, which gave the husband the function of legislator, judge, and party in one person, while taking women's legal personality away. Swiss-trained lawyer Anita Augsburg had remarked in 1905 polemically that for a woman with self-respect who understands the legal effects of civil marriage, it is, in my opinion, impossible to enter a legitimate marriage. Her drive for self-preservation, her self-respect, and her claim to respect from her husband leaves only the option of extramarital cohabitation. German women failed because the civil law code, as it was the case with other European codifications, especially the French civil code, as we have heard, worked as a strong counter-reaction for emergent claims of women's equal eligibility for political participation. They were an attempt to constrain married women's legal situation to keep the family as the smallest nucleus of the emergent nation-state stable. The myth of the traditional nucleus family emerged together with the legal codifications claiming women's nature was private, and thus it would be natural to keep them in the domestic sphere, as it was natural for men to be the head of the household, as the king was the head of the state, and to rule in the public sphere. Philosophy and law worked together to create a new myth of domesticity that influenced both genders strongly. Especially the German bourgeois movement did not manage to adhere to the former claims of equality based on natural justice or human rights. More and more, they adopted an approach based on difference of the sexes, arguing that women's different natural abilities supplemented man's and that a state could not only be working perfect and in balance if both men and women worked together for the common good. This made for a thin line, as you can imagine, in arguing as women and men used the same arguments, in one case for including women in the public sphere, and on the other side for excluding them from the public sphere. In terms of family law, this turned into a very problematic field, as also the feminists in principle adhered to the ideal of the traditional family. What the feminists understood in any case was that the failure of the struggle against the codification process and the discriminatory rights stemming from the new norms regulating women's rights and duties, especially in the family, was a signal of the necessity of incorporating legal issues in their struggles in general. Quoting, "Women learn to bear the burden of law, they don't learn the law," German feminist Luise Otto had remarked in 1819, when the first German woman set out to learn law in Switzerland, because the German university were still closed to women. In order to change that, the women's movement set up legal ad clinics for women or protective agencies for women and children to assist, most often poor women in their legal claims. The daily practice of these agencies heightened feminists' awareness of the law's role in women's lives. The women's movements called for changes of existing legal norms, but they also needed to create laws where previously there were none, thus infusing their practical gendered experience into legal action. But they also realized that they were missing legally trained female advocates capable of operating at the same level as male lawyers and legislators. Thus, from the 19th century on, feminists desired that educated women participate in the justice system to represent their ideals for a fairer and more egalitarian society. And now, let's leave the German perspective and turn again to the European picture and the challenge by advocates of women's rights against the concentrating effects of the various civil codes. Emergent women's movements all over Europe started to protest the unequal laws. In Poland, Eliza Oreczowska wrote in 1872 a powerful novel as a political protest. In Marta, that's the name of the novel, she depicted the life of a young widow struggling to survive in a society that denied women basic legal rights. This novel preceded her emergence as an outspoken leader of women's rights in Poland in the 1870s. In the next phase of Polish activism for legal reform, the women's rights leader Paulina Kuchalska-Reinschmidt would urge divided reformers into a federation to address priorities such as civil code reform beginning around 1905. In 1896, the Romanian Women's League petitioned the Assembly of Deputies to end the subordination of married women, to improve women's civil rights and autonomy as individuals and within the family. In 1864, the Italian feminist Anna Maria Mossoni launched her critique of the new Italian civil code, faulting it as a detrimental to women's rights and the position in society. She acknowledged the power of the law to place the destiny of the families in the hand of man and its concurrent impotence to grant to men the skill to guide their families. In France, the civil law remained a potent symbol of women's inequality. On the centennial of the promulgation of the code in 1904, a coalition of French feminists engaged in a series of disruptive protests, including an attempt to burn a copy of the code at the Place Vendôme in Paris to register their disapproval and its role in treating women like minors, convicts, and madmen, and for violating democratic principles because it encourages men to annihilate, oppress, diminish, and exploit women. Activists also attacked women's unequal status under common law, from multiple venues. In England, Caroline Norton fought back against the abuses of her husband, and she and other feminists would see acts of parliament passed to benefit all women through the custody of infants, 1839, matrimonial causes, 1857, and the first Married Women's Property Act in 1870. Gradually, married women became legal subjects endowed with legal capacity and property rights. Different than in continental Europe with its codes, the process was forged by the changing of laws and precedents by the courts. In England, the more liberal parliamentarism, which allowed an early democracy, at the same time had women under the strongest legal tutelage. Women did only exist in the form of their husbands, as we have heard. And also, the suffragists women resolved partly to violence in England in order to overcome the many obstacles the same parliamentarism raised within in turn was answered with brutality, as we know. Similar patterns as I described, we can observe in all other European countries. Typical for the first failed attempts with a history of legal aid for women is the closely connected to the women's rights movement. Here I would like to point out another feature of the European women's movement struggles for equality, especially in family law, the common international struggle. At the end of the 19th century, the agendas, the major national and transnational women's rights association featured inquiries into the legal status of women and strategies for amelioration. In 1878, at the first International Congress of Women's Rights held in Paris, female lawyers extended the criticism of the legal oppression of women and the arguments for reform. The International Council of Women, founded in 1888 in Washington, and its national affiliates, which also prioritized the reform of women's position under the law, continued in this tradition. Women's rights congresses created opportunities to compare the laws, legislation, and social structures that shaped women's position in society. Within the women's rights movements, comparisons of law and legal system constituted essential knowledge used in national contexts to pressure governments for legal change. Women's rights associations were nationally based, yet many activists saw their fights as simultaneously belonging to a larger European, if not global, struggle for liberty, equality, and sorority. They used the international platform for early on to make their voices heard among diplomatic circles on matters of international law. In this time frame I'm talking about, meaning the turn of the century more or less, we also see a focusing on women's suffrage in most of the national and international branches. So some women's organizations put their fights for women's equal rights in the family on hold with the argument to first gain suffrage in order to change all the other laws later. This is known as the suffragist crown argument or model, while other movements kept on struggling on different levels, especially the national movements that were less radical and had to move more careful due to the respective situations and had a altogether much more moderate outlook. In any case, law reform halted in this time despite all the women's efforts. This only changed, let me get, this only changed after First World War, because First World War led to a big change in Europe in general. The Versailles Treaty brought the formation of new nation states in Central Europe. Most of the nations in the eastern part of Central Europe declared their long-desired independence after the decline of the Austrian Empire, the Russian and the Ottoman Empire, as well as the defeat of Germany following World War I. Estonia, Lithuania, Latvia, Poland, Hungary, Yugoslavia, and Romania emerged as new states with populations of plural ethnic backgrounds and often harsh social tensions between linguistically different nationality inside new borders. Conflicts which had a strong impact on the new democracies. In the process of nation building after World War I, religion, nationalism, cultural background were factors influencing conceptions of man and women's citizenship and political rights. Most of these countries, except Czechoslovakia, experienced democracy only briefly, for the political system collapsed and was replaced with one kind or another of authoritarian regimes before all of them came under the Soviet rule in the 1940s. In the newly formed nations in the East or Central Europe, in comparison, who had been under foreign domination for most of the 19th century, or even longer, women's movements started to form in a stronger sense only with the formation of the new states. In the absent tradition of political activism, the national elites, mostly intellectuals, gathered in an association affiliated with political parties, which primarily were responsible for expressing the demand for women's rights. Thus, most of the women's movements developed together with the nationalist movements. In fact, often the national movements was the precondition for the women's movements. One problem arising from this fact was that the women's movements were not only characterized by the split between the civic women's movements and the socialist-communist divide that we see, for example, in Austria and Germany, but also divided between ethnic groups. Czechoslovakia and Hungary, for example, featured a German, a Czech, and a Slovak women's movement who developed separately and worked together only in some instances. While this weakened the possible impact of the women's organizations in the society, this fact was balanced by the fact that most of the societies were more willing to give women equal rights from the outset than the classical nation or the Western countries. Often these ethnic groups who had fought for their independence and had suffered an inferior social, economic, and political position considered women their allies and clearly saw their important role of the nation in the nation building, which led to an early understanding of equality between the sexes. At the same time, societal expectations overwhelmingly pressured women to fulfill the roles of wife and mother within the family, a situation reinforced by the unequal civil laws. But the aftermath of World War I did not only bring a new division of territories, but the new emergent democratic states gave themselves rapidly also new constitutions, which often declared equality between men and women, and more often than not also passed suffrage laws for women. While this major claim was fulfilled, many other critical women's legal issues remained, such as the question of married women's nationality, the right to legally possess a title to property when married, and especially equal rights within the family in general. So all of them lagged behind with adaptation of these constitutional rules to the civil law. But equipped with the new constitutional rights as well as with the first female lawyers who were able to study in most of the states by now, women set out to gain their decade-old struggle to change the family law again. The Czech Women's National Council, for example, led the effort to reform the civil code to grant more rights to women. In 1924, they presented to the government a draft reform proposal on family law. Based on the constitutional provisions establishing the equality of men and women, the proposal claimed to bridge the gap between public and family law and contained a demand for an obligatory civil marriage, equal rights for women as spouses and mothers in marriages. Female lawyers especially led meetings on the legal committee to formulate civil code revisions. Also in Romania, female lawyers such as Elena Popovici and Ella Negrusi were leaders in family law reform attempts. Their target was, in part, the Romanian Civil Code, which was codified in 1864 after the example of the Code Napoleon, resulting in a restrictive situation for married women. In 1923, the National Council of Romanian Women established a legislative committee to cooperate with the Ministry of Justice to work on the modification of the Civil Code. Despite growing public pressure, the work progressed slowly. Only in 1932 did a new civil code came into force that established some equal rights of women in the family and the society. The reform granted married women the right to practice any profession and to sell, buy, or undertake commercial transaction without their husband's consent, as well as property rights over their dowry. Similar patterns we can observe in Poland, where female lawyer Wanda Grabinska-Wojtowicz wrote one of the legal reform drafts on the position of illegitimate children for the Polish parliament, as well as the one for the struggle against prostitution. Lawyer Irena Wotmanowna went on a lecture tour on questions of the codification of a new marriage law and criticized the legal reform code. Them and other female lawyers fought together with the National Council of Polish Women to reform, though in vain. In the Yugoslav state first, it looked as women would receive suffrage without any problem. But in the end, due to Catholic resistance, did not materialize it neither in 1921 nor in the new constitution, nor in 1931. And though women were broadly mobilized, in Belgrade, Zagreb, and Ljubljana, they became centers for women activist organizations. In 1919, different women's societies and feminist groups unified into the National Women's Alliance of the Kingdoms of Serbs and Croats. The goal of the Women's Movement's alliance included equality with men in private and public life, equal education and professional opportunities, and equal pay for the same work. They also worked for reforms in marital rights, such as civil marriage in all regions, paid household work for women, child custody, and pension rights. Similar processes as in all the countries I mentioned, we can observe in Germany, Austria, France, England, and all the other European countries I did not mention now. Despite these efforts across Europe to reform women's status under the law, the earliest comprehensive legal reforms were initially only achieved by the Soviet Union, the Nordic countries, and temporarily in Spain. The Russian Revolution of 1917 was the beginning of a long process of changes in women's rights that brought important, if limited, changes within the new nation and sent inspiration beyond its borders. The Bolshevik Family Code of 1918 ended women's subordination to men within the family, divorce became possible, and other laws protected women's property, unwed mothers, and women's paid labor. The Bolsheviks used law as a tool for societal change and sought to equalize women's legal status. In practice, though, women's status within the family was resistant to the legal and ideological change because women's capacity as mothers reinforced their unequal social status. Most of the reform potential went unrealized, especially since under Stalin's leadership, women's rights were undermined and selectively overturned, which by the 1930s resulted in a policy based on a repressive strengthening of the family unit. Similar developments characterized all the European countries under communist rule during and after World War II. Spain also passed reforms in the 1930s. Historically, Spanish society and law had maintained conservative gender roles, due in part to the influential role of the Catholic Church. But with the successful establishment of the Second Republic in 1931, the parliament granted suffrage rights to women, and with relatively little opposition, laws aimed to equalize power relations within family law. Gender equality, however, was unpopular and was reversed by the coup d'etat by Franco in 1936. Only late in the 20th century did Spain re-establish women's legal rights in family law following a renewed women's rights movement and a shift in mentality. The French came close to passing meaningful reforms to emancipate married women in civil terms in 1938, but encountered setbacks under the Vichy regime as well. Exceptionally, only the legal reforms approved in the Nordic countries at the beginning of the 20th century proved to be enduring. In the rest of Europe, only by the 1960s and 1970s, comprehensive family law reform, which had previously been stymied by opposing political interests and disrupted by the war, was achieved. So we're coming to the last point, the international women's aspect, or international aspects of the fight. The international work of many of the inter- or transnational women's movements kept on going since its founding times. In fact, their international efforts occurred at a key historical moment when, during the interwar years, transnational women's society sought access to the League of Nations as the site to lobby for universal solutions to problems related to gender inequality. These women's associations pursued international law as a neutral vehicle for taking on the world's most complex issues or pressing problems. Their members viewed the law as a moral or reasoned force, an echo of the Grotian tradition of international law. Most pressing here was married women's nationality, which turned to the focus point of women's pressure besides suffrage laws for the women in the countries who haven't received it yet after the interwar years. But after the First World War, I mean. But family law was also present on women's organizations' schedule in the League of Nations. I don't want to go deeper here, but only stress the ongoing existence and the ongoing pressure also on the international organizations level, which gave the women's movements a power position they never had before. I would like to introduce an organization here, though, small and not so known, because they worked especially the family law. A small group of female lawyers, whom you can see also in the slide on the upper part, was founded in Paris in July 1928, and it was called the International Federation of Female Lawyers and Judges. This association was the first European legal women's organization whose purpose, according to the founding regulation, was to find universal solutions to the problems of discrimination of women in law. In 1929, the first conference of this association, which dealt with the professional prospects of female lawyers, but especially with the equality of women in law and the idea of peace, was held in Paris. In 1929, they joined the League of Nations as a lobbying organization and collaborated with various other international and national organizations. The European female lawyers met annually in different European cities. Conference topics were often family law issues. In doing so, the women lawyers joined the insights of the other international women's organizations, such as the International Council of Women, which was founded in 1988, as I already said, the International Women's Suffrage Alliance, and later also the Women's International League for Peace and Freedom. All of them had been working for decades to find global legal solutions to legal questions of gender equality. It seems altogether that women had earlier, or at least at the same time as international male lawyers, an awareness of the importance of international law for a solution to escape discrimination against a minority group, although of course women never were a real minority. They formed women's parliaments in which, these associations are a kind of women's parliaments in which individual nations sent delegates who had equal voting rights long before the League of Nations even existed. These efforts were continued in the interwar period as the Female Lawyer Organization and in many other international bodies as well. The outbreak of the Spanish Civil War as well as Second World War did not end these efforts. On the contrary, they were taken up by many women's organizations worldwide in view of the humanitarian state of emergency and keep on until today. German lawyer Marie Munk, who had just arrived in exile in the USA, gave a lecture at the 1933 International Women's Congress in Chicago, in which she said, I'm quoting her, "There are many questions in marriage, divorce, and family laws which ought to be solved by cooperation between all nations. Therefore, as far as the interests and the conditions of the respective nations may ever allow it, we should try to realize an international law which would unite all nations and which would be the best foundation for a future League of Nations." Quote end. The female lawyers especially, but the women in general and on a transnational level, tried to find a common basis for legal reform on a global base, based on national rights. Surprisingly, these early efforts to establish international law are not mentioned in any of the stories about the emergence of international law. Firstly, because the contemporary jurists did not take the movement seriously for a long time, and today not because contemporary legal historians or legal scholars seem to be unaware that even at the beginning of male-written international law, women already had established a parallel network to find international legal solutions. Coming to a very fast end now. I think we can see how the legal codes provided the framework for limiting married women's rights, and how in turn women used the law among other tools to try to escape their situation. We have seen that the history of women's movements used similar arguments and strategies to gain their right. This is partly the case because the struggle for equal rights in the interwar period also had an inter- and transnational level, which was also strongly linked to the national struggles. Here it is clear that the national level cannot be, and the international level cannot be seen without each other. To me, it seems there is a more common in the parallel history than patterns that divided their efforts of women, even though all these efforts in terms of equal rights in the families proved to be more persistent to break away than suffrage rights had been. Women factually only were freed of these legal limitations late in the 20th century. The questions of gender within the intersecting spheres of family law, political rights, and citizenship continue to resonate within our increasingly interconnected world. More reform wait to be addressed, such as equal pay for equal work, tax laws, legislation on prostitution, and the division of labor within the family. The latter, of course, is not a subject to legal change anymore, but to mental change, but does in turn still strongly limit women's chance to factually live equal lives and have equal rights. While the legal change most likely will come, the mental change gradually might or might not happen within the next generations. Thank you very much.
Thank you very much for this very interesting lecture, an impressive overview of the situation in Europe over the span of over 2 centuries. So I'm opening the discussion now. If anyone has any questions, please turn on your microphone and speak up. If someone is unable to speak for some reason, you can type the questions in the chat and we'll read them out loud. Professor Vujadinovic.
So thank you, Marion, for this fantastic lecture, really. And if you don't mind, I will put a few questions. The first 3, and it's not necessary that you respond to all of them. First 3 are more related towards summing up of your ideas from my point of the question. And then I have 3 questions regarding your opinion, about which I'm curious to hear. So not necessary to respond to all of them. First, why did the revolutionary men of the 18th century forget women? The second, why the enlightened codifications did by definition limit legal personality of women, especially of the married women? So we know somehow the responses, but I want to hear maybe once again the summing up responses. Why did women movements put much more or have been putting much more accent on public issues and suffragette movements on right to vote, education, work, and much less on the family law issues and family issues? And then a very important question for all of us. You mentioned at the beginning that this conference also is important because you believe that this approach, gender-sensitive approach, has been underlearned or, let's say, underestimated, marginalized. So why, in your opinion, why the mainstream legal education has been persistently suppressing this gender-sensitive approach? It really is one of the crucial questions, and how to change it. Then why the implementation of the contemporary, much more progressive compared to 18th and 19th century law, in the implementation still has been not fully oriented towards the implementation of already achieved gender equality oriented rights. And why, that's also interesting for me, why, in your opinion, the Nordic countries, so what in their cultural heredity has been contributing persistently from in the modern history to their more advanced approach and contributions to the gender equality in different public, private, etc. law and generally in social, political, and other dimensions. Thanks a lot.
Okay. I try to find an answer. I think there is one answer going through almost all of your questions. Why did they forget women? Why did they put married women's rights into the code so strongly? And why women concentrated first on public issues and education first, then on the family? I think men forgot women or women's rights basically because of the division of gender roles. Women were supposed to remain in the families, and more, as I tried also to explain, the question of the family. I mean, the family was always a strong structure or piece of structure in the state foundations or city foundation or kind of territorial foundations. But with the industrialization and all the changes in the world and the nation states, it became loaded with a new content. And this content was that they formed it as the smallest cell of the state, which was the one that was supposed to be stable, while the rest all changed. And so I think with that new charging of the family, with this capsular function, it was also more necessary to keep women out of the public area and to keep them in the family. And at the same time, also women's situation factually changed. That is what we see a lot in the French Revolution, with the first moment when women stepped out of their roles and claimed publicly their rights, they came and they shut them down effectively. That is one of the answers that, for example, Ute Gerhard is giving for why French women had such a difficult time of pushing through their rights when they were like the first to claim then they had a strong women's movement, but they did not manage. They got their suffrage rights in 1946, later than almost all the other countries in Europe. And she explains it by the strong resistance of men to the women's movement. Exactly because they were strong, the reaction was stronger. And that is one of the answers I think that we can generalize all over Europe. It might be now, especially for France, but we also see it in England. There was a strong women's movement, and the reaction was much more strong and more violent than in other countries. And that is also the reason why many of the other movements, especially in Eastern, Central Europe, or also in Germany, were much more moderate in the outlook, because they were like by the law already restricted also by public laws. Women in Germany after the revolution were not allowed to publish newspapers. They were not allowed to organize themselves. So they had to find a less obvious way of organizing themselves, and they could not do it around political issues because that was forbidden. So one of the reasons why they flocked off in education was because that seemed to be more harmless topic. But at the same time, it is not harmless because education also leads to awareness. And the argument was harmless. No, only educated mothers can educate the kids very well. But at the same time, the women educate themselves. And they step out. And then they step into the social areas. So they do welfare work, which is already a public work. It is already outside of the home. So they are gradually expanding their areas of work without men noticing that they already stepped out. But at the same time, of course, that is due for bourgeois women and for the upper class women. Of course, we have the lower class women who have been working all the time. I mean, that is one of the issues that we usually overlook. But the situation I'm talking about basically is a middle and upper class issue, because for lower class women, all that was different anyhow. There was no money to inherit. There was no problems who the money in the families would earn because the families needed it to eat. So we're talking also about different issues. But let's turn back to the legal codes, because that's the one that usually regulate the life of this, the importance of the law in the life of middle class families. Yeah, and then, for example, the German women's movement only realized with the changing of the law code how important the law was. I think women for a long time, while being restricted by the law, did factually not realize how much it restricted them, because they never questioned it really. But then women started to ask themselves, so we're doing the main work with the kids and the families. We're the main ones doing the work in the family in general, but why don't we have rights in the family? Why is it that the man has the last word in the education when we are the one who are doing the work? And that also looked like a less political approach to laws than suffrage. So they asked for that, but also maybe themselves not really realizing, men in any case did not realize it, that asking for a full legal personality in civil law, of course, is a precondition to get civil and political rights. I mean, you see that men realize it, and that's why they keep it so strongly. And first to keep their own power, but also to keep the women out of the political rights. So we have like a strong connection, like I say, an interdependence between family and public laws. But the public laws, that was always the one that they put like highest. We want to keep the women out of that. But in effect, women gained earlier rights to public officials, to suffrage rights than whites in the family, because there it is like giving up the power position in your private life as well. So I think that is the reasons why it took so long and why men were so consistent and why they were also, why they put women under married women's tutelage after freeing women in general. You know? It is kind of legal trick, you know, to say everybody is equal, but the married women, they are not equal. They are still under tutelage. So I think that more or less answers your questions 1, 2, 3. Why did the research come so late? I guess that when the research...
Why the mainstream legal education has been persistently underestimating, marginalizing this gender-sensitive approach to law?
I mean, I cannot answer that for all legal systems, but the German legal system, I think they have their canon, which they are teaching, and I don't think they have many ideas of, or even a will to extend. We're still learning the same stuff since the law studies were introduced, and especially the German legal education is very much structured for all of us to work into for the state. And of course, the state has no interest in furthering women's rights. I mean, we do have it in our basic law, and but we see factually that it's often more a lip service than a reality. And how to change it, I don't know. I think that needs a mental change, and the mental change is very slow, very slow. Even though now I think the law can serve as a motor for change more than to hold it. I think that many people, also women, are still very hesitant to use the law to get equal, because they feel like when they're helped by the law or being a quota woman, all that discussions that we have now, that they didn't achieve it by their own power, which is, in my opinion, wrong. I think it will solve itself as long as there are 50-50, or like Ruth Ginsburg said, why not having 100% of women and then slowly it will change. But seeing the power structures and hierarchical structures as they still are, I don't see it coming very soon. And why did they concentrate on one law, suffrage? I think that depends a little bit on the strategies. Like I said, English women and American women could afford to do it because they were principally free enough in that kind of open democratical. I mean, they were not exactly democratical, but much more democratical than the systems in continental Europe. So I think they could already step ahead and demand something that was like totally out of the possibilities of thinking in Central Europe or also in France. So I guess that women in continental Europe started to ask for educational welfare and family law reform movements, first of all, because it was obvious that they also had to be changed, and as preconditions to go there. But also realizing, at least in Germany, that the family law was as much as important, if not more, than suffrage laws. I mean, for the daily lives of women, because we go voting once a year, but in the family we are discriminated every day of the year, no? And why the Nordic countries earlier? I personally haven't done research on that topic too much, but what I'm reading is that it has a lot to do, and that is more an opinion that I express now than research that I can already say it is like that. I think you can see it also in the US, in the West and the East, with the suffrage rights, no? That in the West of the States, the suffrage rights came earlier than the East. I think it has to do with the fact the more tight and set the nations or communities already are, the more difficult it is for women to break out of these roles. And the more open and less firm the societies are formed, women have more right because they are needed. I mean, the working load is needed. And that is why Australia, New Zealand, the east of the US, and the Nordic countries in Europe, which are, I don't know whether it is true, but I would guess it is true, that are less organized, have a stronger estimation for women. And they included them early in the process because they needed them. And then, of course, the fact that they associated with men, that is also something that the women's movements helped. The US movements did that, the English movements did that. The German women and the French women didn't have many male supporters. One of the other reasons why they could not break through so fast. I think that was...
Thank you. Yes, thank you.
Should have covered it more or less. And what do you think?
So you asked me?
Mm-hmm.
So the patriarchal tradition and the strength of that being kept for centuries and for millenniums, that cultural background of the manpower reproduced at the state level always again has that, how to say, the crucial role in the whole this story and dialectic of the emancipatory role of the law and the reproduction of patriarchy role of the law, just to say short. So that cultural background, and there must be some cultural differences between, as you said, more open societies, New Zealand, Australia, Nordic countries, which allowed faster steps forwards than in other. So these cultural differences in the strength of the patriarchal tradition, to say in another way, made impact to differences in this still persistently strong, strongly existent dialectic. So yesterday or the day before yesterday during Elizabeth's lecture, we spoke about how still the fight, the struggle of women, as you said, women realize that they have to struggle for themselves, by themselves, so that struggle still has been necessary, because again and again, for example, with the current ethno-nationalist or right-wing movements everywhere in the world, from the United States to East European countries, everywhere, they have again been putting into danger the already achieved female rights. So again and again, the struggle of women and support of men is necessary for keeping and advancing the rights of women. But for me, it really is a little bit, I understand and I agree with your response why the mainstream legal education has been still putting aside this approach. But it really is so necessary to be introduced into the legal, to become the part of the mainstream, because of the necessity of further changing the situation.
Absolutely. The more valuable your approach in Belgrade is to introduce now that master. I really like that idea.
And please join us in our effort.
Very, very welcome to do so.
Good, thanks you, thank you.
Any more questions or comments? if nobody has anything, I'd just like to briefly comment on the thing you two have already mentioned, the relation between struggle for suffrage and for education and family status. They are frequently related because the position of women in one was frequently put by men as an argument against the other. For example, in many cases when women asked for suffrage, some men argued that they shouldn't get it because women aren't sufficiently educated to know for whom to vote, to understand politics, or because that would mean granting double votes to married men, because surely a wife would vote the way her husband tells her to. So all those things are related. I apologize. That's my daughter, you can hear.
We all know that, don't worry.
So just one more brief question. What do you think, how much in all these codifications, struggles for big changes, how much does the personal factor of those key persons involved play a role? Because, for example, when you talked about the French Civil Code, you mentioned very reasonable arguments about the general attitude towards the women's movement in the French society, but I've also read that Napoleon's own personal upbringing had a lot to do with it, because he was a Corsican and they are particularly patriarchal and so on. So what do you think of the relation of these factors?
Well, they surely play a role. I mean, if you see it, the French Civil Code was drafted by lawyers. But Napoleon, for example, the limitation of the rights of unwed mothers was what he personally put in. So you can see that, of course, persons always play a role, and much more in some legal systems than in others. For example, in the English system, one person who sues and gets like a precedent case can really change the world. That is not so much the case in continental Europe, because there you have to change the laws, which is much more difficult. One of the reasons why probably also the English and American movement is stronger, because they have the courts to work for them. The continental women, first of all, because they could not go to court, but even they could have gone to court, they could not have changed the law. Then you would have to have a judge who sets it out if there's a general rule that would justify it, and then it would go to, so it goes nowhere. So, for example, Caroline Norton, I mentioned in the English system, she was not even a real feminist, and the real feminists were upset with her because she pushed through something they have been fighting for on another level for all the time, just by suing the court. And then she claimed the entire success for herself, even though there was a big movement fighting for it. So we even have a kind of competition between women sometimes, because women manage, one single woman with her court case, who was not part of the movement, pushed something through, and she was not part of the movement. So they could not claim it as their success, you know. We have like so many problematic moments in that. But yes, I think the personal issues are always there. And you see it especially because one person can make a difference, and maybe a small one, but still. You see it with Ruth Ginsburg now. What a difference one person can make, still. That is sometimes what keeps me up when I'm feeling like nothing will ever change. And I think that all these people I worked on, they also have made a difference, and in totally different ways. That is also something that has helped me through my legal studies, which I never liked. I actually hated them. And then we have the problem with the grading in Germany, which seems to be and is very arbitrary. And when I studied the female lawyers and in the end saw that they have like totally different careers and totally different participations to the issues, and it was not depending on their grades, that also helped me. You can become whoever you want depending on how good you are in your legal studies. Maybe not a judge, but you can participate in different ways, and all of them are meaningful.
Thank you very much. Does anyone else have any questions? If not, then thanks once again for the wonderful lecture. Thank you everyone for listening. We're going to make a short break now. We're a bit ahead, so let's take a 10-minute break so we can stretch our legs and so on, and see you here again at 11:35 when we're going on with the first session for today, so women's position in civil law.
Thank you very much for having me.
Thank you.
Discuss for me as well.
Bye. Thanks a lot. Bye. Thanks a lot. Bye.